Hello, my name is Vedant. I am a legal intern with LEXIS and Company. First of all, before starting the video, I would like to say that please like and share this video and subscribe to our channel, YouTube channel. And also a disclaimer that this video does not promote or advertise anything about the company as per the BCI guideline. These videos are only for educational purposes. So, today's topic that we are going to discuss in this video is about the well-known trademark and the law related to well-known trademark in India and how it came into existence. So, well-known trademarks plays an important role in the global markets and in identifying symbols and signs that are widely known to the significant general public and enjoys a fairly high reputation. The first time well-known trademark was discussed was in the Paris Convention of the Industrial Property in 1883, wherein the said convention set out certain guidelines for protection of well-known trademarks, but they did not lay down any procedure per se, and hence left it to the signatory countries to make their own rules and regulations for registration of such trademarks. All the countries generally have accepted the significance of well-known trademark, including India. India has given well-known trademark exceptional rights over registration of identical or deceptively similar marks and also against their abuse. The lawmakers in India have made specific provisions for safeguarding the well-known trademarks in the Trademark Act 1999 and the Trademark Rules of 2017. As earlier, the well-known trademark were protected under the common law regime from where the passing of was formulated. Well-known trademark is defined under the Trademark Act 1999 as in relation to any goods or services, a mark which has become so substantial segment of the public which uses such goods or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to the first mentioned goods or services. India has been protecting well-known trademarks from a very long time, and before having it defined under the Trademark Act 1999, India was following the common law to protect the same. The Trademark and Merchandise Act of 1958 did not provide for any specific provisions under which well-known trademark was defined, and it was only protected under passing off. Furthermore, there have been judgments by the various high courts in India which provided for protection for the same. There are many cases in India for protection of well-known trademark, and one of the most famous case was of Dalmia Benz versus Hybo Hindustan. In this case, the plaintiff was manufacturer of Mercedes-Benz car and the defendant was using the mark Benz, B-E-N-Z, for selling its undergarments. The court, in deciding the case, acknowledged the logo of the plaintiff as a well-known trademark and hence restrained the defendant from using the same impinged mark by stating that there was no valid reason as to why the defendant would adopt the name Benz, which is associated with one of the finest engineered cars in the world and has a trans-border reputation and goodwill. In another case of Rolex versus LX Jewelry Private Limited and others, plaintiff filed a case against the defendant who were dealing with the artificial jewelry and using the trademark name Rolex associated with the plaintiff. The court held that the plaintiff's mark made was a well-known trademark since the general public uses watches recognized the trademark Rolex, and the defendant using such mark for dealing with artificial jewelry would create a confusion in the minds of the general public and might create an assumption that the product and are those of the plaintiff's company. Hence, the court granted injunction against the use of the trademark in the name Rolex by the defendant. In another case, the Delhi High Court held that in case of Microsoft versus Kurapati Venkata Jagdish Babu held that the mark Microsoft was a well-known trademark since it is being used and known to the most of the general public throughout the world, while also considering extensive evidence in relation to advertising and publicity of the mark in India. The court held that the defendant were not allowed to use the mark either as trademark or as part of its trading style or corporate name in relation to similar or dissimilar business, as the said trademark has got a unique goodwill and reputation around the world. So this was all about what are well-known trademark, how it came into being, what Indian law says about the trademark, and how Indian courts have interpreted the clause well-known trademark and given protection to the well-known trademark. Thank you. Do like and share this video and also subscribe to our YouTube channel. Thank you.